I'm just going to throw my hands up and to say that that's an excuse. Again, notable from she only started making these payments, I believe, in March or April. Children have been in daycare since January. And again, she's just making essentially a $50 payment toward what amounts to a $1,000 bill. That is not good faith. When you look at her income, again, just blatant dishonesty with the court. She'll tell you what you want to hear the day you want to hear it to get her way. You look at back in December of 2022, she claimed, and we put it right in the reply, that her net income was $3,189. This is her statement. We are now 7-8 months down the road. If anything, she's gotten a raise, but now she claims that her net income is $700 less a month. Well, that $700, there's just no evidence that supports a reduction of $700 a month in her income. No basis for that reduction. And if she had been applying that $700 a month toward the children's daycare expenses, we wouldn't be in this position. That would be good faith to say, oh, this is every bit of extra I have. So again, even within the course of 6 months, she's just talking out of both sides of her mouth. These claims that, oh, gee, I self-helped for offsets, those are really throwaway arguments. First, latches in the sense it was never raised until my client said, hey, you owe this child support obligation. Never once raised in the more than year she says that obligation existed until my client asked for a payment. So if it was a real obligation, she should have been asking for it from the minute the order was made. Two, if you're using basic law school contract principles, the order is construed against the drafter as to any ambiguity. This was drafted by her counsel at that time. And two, and three, you can't self-help. This idea that, oh, well, I'll just offset these things is not appropriate. But we do have two prior contempts in this case, one regarding finances, one regarding the parenting plan. This would be the third. There are very real consequences to the children of this action. The children have now been removed from daycare due to non-payment. That is a very real negative consequence that the children of this action now have to deal with, and that my client has to deal with, because he can't afford to manage everything on his own financially. The child support is a right of the children, and this is just saying, I'll do what I want. I'll pay what I want. Sort of shrugging her shoulders at the consequences. And that is not appropriate. This is somewhat a disaster at this point, because it takes so long to have these matters heard. It's really a disaster of Ms. Gibson's making. She's done something that has financially harmed everyone and is actively harming the children. Daycare spaces can be precious, and getting them back is a question mark on whether or not, even if she pays now, there may be now a waiting list where my client has to choose more expensive options because that's all that there is. Given this, the order only calculates arrears through June. That's fine.